In Delphi, Indiana, we have a new update on a motion filed Wednesday by the state to obtain Richard Allen's mental health records. Now, that motion has now been withdrawn. Allen is the man accused of murdering Abby Williams and Libby German in 2017. State prosecutors were seeking Allen's mental health records for the third time. They claim they needed them to prepare for trial because it was obvious from defense filings that they planned to cite Allen's mental health as a way of explaining multiple alleged confessions made by him while behind bars. Now, in their motion filed yesterday, prosecutors stated in part, the defense has expressed concerns that Richard Allen is being treated unfairly or is being placed in conditions that resemble a prisoner of war. The state has filed a motion for leave in the past to obtain these records, and the defense objected to said motions. And in an exclusive interview back in January with Court TV's own senior documentary unit producer Barbara McDonald, Allen's former defense attorney, William Librato, said that Allen's living conditions were unlike anything that he's experienced.
We had visited him on several occasions, but, you know, driving 4 hours each way was difficult. And then at Wabash, they're not set up for visitation, so we were literally in a makeshift kitchen, and he was in a cell. We had to stand 6 feet back, and he's talking through the slot where they put the tray of food through. And that's not a very conducive way to have meaningful conversations with your client. I couldn't hand him documents. I couldn't have him sign documents. And, you know, I'm sure it was very difficult for him to see the videos we were showing him through that slot. So, you know, I'm not criticizing the Department of Corrections. I mean, for whatever reason, he was moved there. They're not set up for visitation, but you can't have I couldn't have been prepared for trial even in October if that was how all the visits were going to be conducted.
And you've handled death penalty cases. Have you ever had a pre-trial defendant treated the same way as Richard Allen?
Never. Never. In my 25 years or Stremin's 25 years have we ever had a murder client held pre-trial in a maximum security facility and then was transferred from one maximum security facility to another. Never.
And in your motion to transfer, you guys described him as being treated like Hannibal Lecter.
Particularly in Westville, at least we were allowed to sit face to face across the table from him. But the way he was handcuffed and to his chest, I mean, it looked extraordinarily uncomfortable. I couldn't shake his hand. We couldn't have him sign anything. I visited clients in prison on several occasions. That was different than anything I've ever experienced before.
And the way his hands were shackled were similar to how we see him in court, right?
Yes,
Where
exactly
it's like the
way.
tops of the hands are touching.
Yes.
And it's way up high on his chest.
It's connected to a box on his chest. I've never seen that. I've never seen anyone confined in that manner before.
So why? Why do you think that is?
I don't know. He is 5'6", 120, 130 pounds. He is not a physical threat to anyone. From all accounts, he's been a model citizen because he's locked down 23 hours a day. We told the confinement officers that we wanted him unhandcuffed so we could shake his hand and maybe have him sign documents, and they weren't budging on that. And it was sad because Westville allows visits, so his wife could come see him. And they just set up a visit with his mom and dad. He was transferred to Wabash 2 days before that visit. Now, I don't think one had anything to do with the other. I just think it was bad timing and a coincidence. But in Wabash, you're not allowed any visits. Obviously, attorney, but no family members.
Now, today's filing for the withdrawal states in part that the state was notified by the defense on March 7, 2024 via email addressed to the judge that the filing should have been sealed and that the state should not have been given access. This comes after a filing by Allen's defense team earlier this week seeking a speedy trial. The defense is requesting a trial date within 70 days from March 6th per state statute. Allen's trial is currently set to begin on October 15th of this year. All right, let's bring back in our guest joining us to discuss, Deputy Chief of Investigations for Gwinnett County, Georgia, Curtis Clemens, and Deputy Public Defender for LA County, Philip Dubé. And Philip, I want to start with you because this was one of those oops and uh-oh moments by the state. Here's the problem. They apparently got access to ex parte communications they should not have had access to. Not only did they get access to it, but they used some of the verbiage from those documents in their motion seeking the mental health records. A lot of people came out. Some of the lawyers locally said this is extremely unethical. Number one, I want to ask your opinion and what you think about that. But number two, I mean, it's just outrageous. How does this even happen?
Well, first of all, I think it's absolutely unethical for anybody on the prosecution team to use privileged evidence as a source of probable cause for anything. They're not supposed to do that unless, of course, the defendant, him or himself, is willing to waive the privilege. And under Indiana law, for example, psych records from any psychotherapist who falls within that category of psychiatric or psychological providers enjoys that privilege. And absent a waiver of that privilege by the patient, him or herself, those records are confidential. There are a few exceptions to that under Indiana law, and that is if he decides to tender his mental state at trial and he's going to call experts to the stand or treating doctors, then I think it's fair game and the privilege is arguably waived. Additionally, I think Indiana has a statute where if you, in fact, made very specific statements to one of your psych providers regarding the homicide itself, I think it's an exception to the psychotherapist patient privilege under Indiana law, and they can get it. But it's dangerous because right now everything is a wait and see. Not to mention there's civil liability under federal HIPAA law. It's the Health Information Portability, Accountability, whatever it stands for, federal law that protects the medical privacy of all patients throughout the country. And there's tremendous consequences for violating that statute. So I think it's cleaner to just withdraw it and wait to see if the defense decides to tender that mental state.
Yeah, no doubt about it. Now, the mental state won't go to an insanity defense, Curtis. They're not talking about that. What they're talking about is apparently he's made a number of phone calls and had alleged confessions to his wife about committing this crime. They want to call somebody in who's an expert on coerced confessions and make the implication that the way he's being treated, and that's why we played that side about the way he's being treated, and it's been a complaint throughout by his defense attorneys that he's not being treated well, not only in the way he's being kept, he's in solitary, but also his treatment by the folks in the jail. All of that could be the reasons that he made these confessions. What are your thoughts on that?
Well, you know, we can make accusations about what they believe or how they believe he's being treated based on that, you know, the few interactions that they had with him. But typically when you're in a maximum security prison, you're there for a reason. Either you've displayed some forms of violence against yourself, other detainees, or the staff at that facility, and you may become a danger to yourself or others. Yeah. That's why you may be in that situation. However, all that aside, he has to have his rights abided by. Mm-hmm. And outside of that, they're gonna have to play fair. There's no going back or trying to have access to privileged information. And until the defense says, this is what we're going to do, they have to back off.
Yeah. Philip, I want to check in because ultimately the explanation by the Department of Corrections is that he's a danger to himself. They're afraid of that. But some of the treatment that he's received has really, at least as explained by the defense, has been outrageous. What are your thoughts on that aspect?
Well, first of all, if he's a danger to himself, they can make that assessment based on who's treating him in the jail itself and get him the help that he needs from the doctors within the institution. They don't have to go outside the institution, get into his private chart, and then use that information against him substantively at trial. I think that's outrageous. Now, if he, in fact, has any type of medical problems or mental infirmities while in jail, they're free to treat him, and that's what they're there for, to help him.
Well, quickly, let me ask you. What I meant was, how do you think it relates to the possibility that he gave a false confession to his wife, for instance?
Well, you would have to show that he was on some type of psychotropic medication that rendered him unable to control his thoughts, his speech, and he just rambled kind of incoherently and said things that incriminated him.
You know, I gotta say, you know, we've seen many false confessions under circumstances where you keep people in a room for 12 hours and you make them feel a certain way, and they'll tell you whatever you want to tell them. Your mind can play tricks on you.
But you have to look at, are they under duress, or was he under some type of medication that was making him just rabble on about, you know, what he's hearing? But was he under duress when he was making these statements or confessions to not only his wife, but his mother as well?
Yeah, that's right. It's going to be a real issue at trial.